In this module, we will look at the judiciary in England and Wales. The principles of judicial independence and judicial neutrality are central tenets of the judiciary. Under the principle of judicial independence, judges should be protected from political interference and control. Judicial independence is preserved under the UK Constitution through the principle of sub judice, which means that Parliament does not comment on the cases which are before the court, and parliamentary privilege, that members of Parliament are protected from prosecution in certain circumstances by the courts. The Constitutional Reform Act 2005 contains measures that enshrine the independence of the judiciary. Thus, the judicial selection and appointment process, for example, is designed to minimize political interference, focusing on the role of senior members of the judiciary in the process rather than the politicians. As long as judges hold their positions in good order, they remain in posts until they wish to retire or until they reach the mandatory retirement age of 70. Further, judicial payroll salaries are determined by an independent pay review body, which makes recommendations to the government, who will usually accept and fully implement them. Judges should be politically neutral. This principle relates to the doctrine of parliamentary sovereignty, i.e. that Parliament is the ultimate source of legal authority and is not constrained by any higher court, with the exception of the European Court of Justice. This means that judges cannot overturn an Act of Parliament for being unconstitutional, and requires that judges be neutral in their approach to the law and seek to apply laws passed by Parliament in an impartial, unbiased and technical manner.